Afternoon, everybody. Do you know, I had to look at the date there, Rachel. I had to look at the time and the date to make sure was I saying good morning or good afternoon, and where are we in the calendar month? I don't know why I took this opportunity to orient myself, but here we are. So good
I'll do
afternoon.
it.
Good afternoon, everyone. Thank you so much for joining us. I am so delighted today to have Rachel on Soundbites. Now, if you've watched previous Soundbites, you'll know that Rachel has been a recurring guest for very good reason. And the last session that Rachel and I did together, we were talking about this. Well, one of the principles kind of deriving from this case, but it hadn't actually happened that we didn't have the outcome of this case. So it follows on from the last discussion that we had. So in posting this recording, I'll make sure that we link the previous episode. Because it's great as well. But anyway, so Rachel Burley Stower is joining us today. Rachel is a community care lawyer at Martin Searle Solicitors, and she represented the claimant in the case that we're going to be talking about today. So there's literally no one that knows more about this, which is really lucky for us. And the topic today is it's all about local authority funding and what the outcome of this important case means for claimants who have personal injury claims and are seeking funds from local authorities. And it's an issue that we grapple with in lots of the cases that we work on, and lots of the claimants um, rely upon funding from local authority, and it's often a really difficult issue. So thank you so much for joining us, Rachel. I'm so grateful.
That's an
Um,
absolute pleasure. Thank you for having me.
no, if anyone has any questions, by the way, along the way, just pop them in the Q&A box and we'll try and get to them. If we don't, we'll pick them up after and come back to people. So I mean, what was my first question? It'll be Rachel, it's a really obvious one, but can you just explain a little bit about the case? What was the case all about?
Okay, so it was a judicial review of a decision made by a local authority, West Sussex County Council. So they decided that they would refuse to fund statutory funded care for a severely disabled applicant on the basis that he had a criminal injuries compensation award, and that criminal injuries compensation award included an amount for future care. So there was of the view that he already had money to pay for his care, and therefore they didn't have a duty to fund that care, and so they pulled the plug on the funding.
Got yeah. So before we move on to the outcome and the kind of the finer details of the arguments, what can you tell me a wee bit about the claimant himself, who he was, what were his needs?
Yeah, so he was a young man. I can't remember his exact age. He's probably late 20s, I think, if I remember correctly now. So he had an acquired brain injury as an infant. So he has both physical and cognitive impairments. He's partially blind. He has a lot of seizures. He has cognitive learning disability, I suppose, mobility issues. He has 24-hour care needs, effectively. He lives in supported accommodation. He has to have a professional deputy. Well, actually, he has two deputies. He has a lay and professional joint deputies who manage his property and affairs. So he's somebody, a very vulnerable young man.
Yeah, yeah. And he had a claim, he had a criminal injuries compensation claim, which is different from a personal injury claim in lots of different ways. But essentially he had access to compensation.
Mm-hmm.
Um, what did that look like, Rachel? Does that matter?
Well, I won't reveal the exact amount, but he had an amount for future care, which is relevant to the case. So it's a lump sum settlement. He had an amount for future care, and it was administered really by the Court of Protection via the official solicitor. So the official solicitor are trustees, and they administer that. So they have to report to the Court of Protection. So
Sure,
that means administered by the Court of Protection.
sure.
Yeah.
And so this, my reading of this, and I've read, I confess I haven't read the entire judgment.
It's quite long, isn't it?
I'm not sure whether I should say that, but I've done quite a bit of reading, and looking at it, this case wasn't kind of just about money. What else was behind this, Rachel?
Well, I suppose I would say really there was three different issues. I think I would say really money is the biggest thing, that umbrella issue. But it was broken down into a number of different points. So for example, so this started in 2017, and actually I've been on sound bites, and I think in every single one of my sound bites has actually come up for different reasons. And so one of the reasons we discussed it actually on the first soundbite was always talking about the drafting of final orders and how very important it is to get the wording right. So in this case, the final order included an undertaking by the original deputy, which said that if he were ever to claim statutory funding under the National Assistance Act, he would first have to make an application to the Court of Protection for permission to make that claim. Okay. Now, as you know, the National Assistance Act is no longer in force. It's now the Care Act. And so when he came to me, I said, well, you can make a claim under the Care Act because the National Assistance Act is no longer in force. Okay. So that was the historic undertaking was an issue. Okay, so the local authority relied heavily on the initial undertaking that was signed by the initial deputy at the time of the settlement. So that's one point. The second point really is a huge point, really, is double recovery. Okay, so we've definitely discussed this on a number of occasions. So the issue is where people are given an amount for future care, or actually very often somebody may be just given a lump sum with no mention of whether it's used for future care, but nonetheless they've been given compensation, and then they approach either the local authority or the NHS and ask them for assistance with the funding for their care. And the local authority or the NHS are calling that double recovery. They're saying they're being compensated twice for the same injury, I suppose. So that's certainly what West Sussex were arguing in this case. And then I suppose related to the second point, I suppose, is the protecting of public purse, because obviously local authorities are strapped for cash and they needed to ring fence what they're spending. And as we know, they are gunning for people and, you know, very often exercising their decisions unlawfully in order to avoid their duties. So the argument really was very much about fairness and principle, as much about fairness and principle as it was about statutory interpretation. So it's statutory interpretation versus fairness and principle. So it's an unusual case to be involved with, to be honest with you. So
it is, and the public policy issues, like, it's super interesting, isn't it? It's really quite pertinent. And in terms of like the legal question for the court, Rachel, the key legal question that they're having to decide.
So the key legal question was really, I suppose, are the local authority permitted to include within the financial assessment a person's personal injury settlement, a lump sum personal injury settlement? Or I suppose the other way of looking at asking that question would be, are the local authority permitted not to disregard the personal injury settlement? So it's the same question posed in slightly different ways.
And I thought the law on that point was fairly clear.
Well, it kind of.
I mean, that's a ridiculous thing to say, actually, isn't it? That there are so many grey areas in every area.
And this is definitely a grey area, and it's actually something that I've been worried about since the introduction of the Care Act, actually. So I knew this case would run at some point. I've been waiting for that case to come along, and it's come along and actually fire a back door, because the issue that actually we ended up grappling with isn't the issue what we really went in with. But anyway, it's now clarified. So under the Care Act, okay. So my barrister, okay, in the court for 2 hours was on her feet, trotting through legislation, regulations and guidance, which relate to other legislation, regulations and guidance. Now, I don't want to lose the audience today, okay? So I'm not going to do that to you because you would die.
Honestly, that's not what we're about on Soundbites.
I don't actually think I've really got the skill set, to be honest with you. She was amazing, Catherine Elliott, big plug for Catherine Elliott, Landmark Chambers. So I would summarise as simply as possible. So we all know that in order to be eligible for local authority funded care, the claimant needs to have 23,250 in capital or less. Okay. Now, most of our clients have got personal injury settlements, and that is way more than 23,250. Okay.
Yeah.
However, under the Care Act, there's a whole bunch of regulations, and in those regulations are what we call disregards. So capital that must be disregarded when calculating a person's capital. Okay. Now, first of all, criminal injuries compensation awards should be disregarded. But for some reason or the other, West Sussex decided not to take that into consideration, and just ignored that particular provision. And then they looked at other provisions. So there's two regulations. One says that I'm ad-libbing, okay, so don't hold me to account on this. It's not word from word, but it's something along the lines of a lump sum personal injury award that's administered by the Court of Protection should be disregarded. Okay, so my client's lump sum, he had a criminal injuries award, it's lump sum, it's a personal injury settlement, and it's administered by the Court of Protection, therefore should be disregarded. However, West Sussex latched onto Regulation 16, which says a lump sum personal injury award should be disregarded except for any amount which was dedicated, well, not dedicated, but allocated, say, for future care. So they loved that second half of that sentence, because they know criminal injuries compensation award did include an amount for future care. But the court were clear that because it is a lump sum settlement and it's administered by the Court of Protection, it falls very, very clearly and squarely within that provision, and therefore it has to be disregarded. They actually said that the wording is clear, unambiguous, and unqualified. I tend to disagree with that interpretation of the regulations, but that's the court's interpretation. And so now it's very, very clear that lump sum settlements must be disregarded when calculating financial assessments for statutory funded care.
And did the council know what the award was, Rachel? Were they entitled to know the amount of the award and how it was allocated?
Yep.
Yeah.
Well, actually, that's a good question, because that comes up a lot. Actually, so very often I'm dealing with professional deputies who refuse to hand over the final order.
Yeah.
And I've had local authorities who have refused to fund on the basis that the deputies refusing to share that information. So they have to share financial information. Okay, so but actually in this case, way before I was instructed, and for reasons I do not know, they already had the order. They had the order before before I'd even come along, so they knew about the undertaking.
Got you. Yeah.
Yeah.
I mean, I wonder how that, I'm kind of thinking out loud, how that interacts with, in cases where there's anonymity orders. And anyway, I don't want to drag us off topic, but
Well, I've absolutely, in those cases, I've refused. We have actually managed to argue that when there's an anonymity order, they don't have to disclose.
okay, got you.
We just work around it so that we can show money in accounts and things like that.
Oh, okay,
There's a
okay,
different way around
interesting.
it. So yeah.
Okay. And we've talked before, Rich, about this principle of kind of double recovery, and I know that that was something that the council relied heavily upon. We've touched on that already. But why didn't that succeed in this case?
Well, I suppose the courts. So this is a judicial review, right? So
Yeah.
judicial reviews look at the decision-making procedure and processes of local authorities. Okay, now really double recovery really doesn't belong. It's not a point which local authorities' job isn't to police double recovery. This is more an issue that should be dealt with under tort law. It should be dealt with at the time of the settlement. It's up to the parties to consider this and make provisions and determine the final settlement with that in mind. Local authorities haven't got the authority to police that. They haven't got the authority to go outside of the duties that are imposed by the statutory guidance or the regulations. The regulations are clear. They set the boundaries by which local authorities are able to operate, and they don't have the authority to go beyond that. They don't have policing powers.
Yeah.
And so that's why this application succeeded, because they are not a moral making authority. They don't have the authority to make decisions based on on policies or on morality.
Yeah.
They're confined by the strict rules which are set out in duties under these regulations.
Yeah, yeah. It's so interesting, isn't it? I mean, so just headlines for, I'm just conscious of the time. I keep saying these are 15-minute episodes, and then I make them so much
Really
longer
long.
by keep asking questions. Um, but what did the court ultimately decide? What was the, bullet point outcome in the case, Rachel?
Okay, so first of all, they quashed, I was going to say quashed, sorry, the decision in relation to future care. So local authority have to fund the future care. They also quashed the decision in relation to recovery of funds that they had already paid. So as I said, the case had been going on since 2017. They had funded on a without prejudice basis until 2024 when they decided to cut the funding altogether. So they can't recover that. And also they made an order that they had to repay the claimant the monies he'd paid on care since 2024 until the date of the actual decision. So everything was refunded basically, and really rejected any of their arguments in relation to policies and what have you. So
And the family presumably were, you know,
elated, yeah.
just absolutely
Yeah,
delighted with the
he
outcome.
was really worried. It's just the dad actually, because the mum has died. So, but the dad was really worried at some point because it took quite a long time to get the final judgment. Because of course you
Yeah.
have the hearing and it takes ages, and so he really had to. He had a big wobble and was really worried that he'd made a mistake and we shouldn't have run it and what have you. So yeah, he was elated actually. So
And it's such a significant decision, isn't it? I mean, so just in summary, I suppose, can you tell us why this case is important, kind of beyond this individual claimant, and how, what deputies and lawyers and families and all the people that are invested in this type of case, what we all take away from this in our own practice.
yeah, so I would say really this is a really landmark clarification of the boundaries of local authorities' interpretation of the financial assessment regulations. So absolutely, we know for sure now that lump sum settlements must be disregarded under the Care Act, and
Yeah.
local authorities do not have the authority to go outside of those regulations. I would say, yeah, well, personal injury settlements and trusts remain fully protected. Local authorities can't sidestep their statutory duties. Yeah, and so and really, I suppose it just reaffirms public law principles that
Yeah.
the duties are strict and the rules are rule based, are not discretionary. The local authorities do not have discretion to reinterpret duties.
I think that's just such a massive point, isn't it? And
Mm.
if anyone needs to take up battle, they can contact you, right?
Yeah, of course.
So I've actually got a couple of questions in the Q&A box, Rachel, but
Yeah.
they're kind of two questions that relate to the same point, and it's a really good one, which
Yeah.
is if periodical payments have been agreed on a case, you get your lump sum and then you get your periodic payments, which happens in lots and lots of the cases that we do. Are those disregarded? Can those be challenged?
Okay, so that is a whole different question.
Is it? Okay,
Honestly,
interesting.
we could have a whole session on this.
Another episode.
Yeah, yeah. And short answer is no, they're not disregarded, in my opinion. But they are being disregarded. So at the moment, most local authorities are disregarding the periodic payments, but I suspect that we'll have a very similar case soon on periodic payments, and I don't expect it to be going in our favour.
Really?
Yeah, absolutely. So yeah, the interpretation of those regulations are so complicated, and actually the answer doesn't even really lie in the Care Act. It actually lies in the income support general regulations.
Mm.
But yeah, in my personal opinion, only £20 per week of a periodic payment should be disregarded, which of course means a huge amount of money isn't being disregarded, which means a huge amount of money would be available to meet care fees. But as
Irresp
I say, they're not. No, that case has not yet been run, and I think possibly this case, my case that we're talking about today, may keep it at bay for a little while longer, because local authorities are going to read it as old personal injury settlement should be disregarded and not delve into the details so much.
Yeah.
I do suspect that at some point in the near future, somebody will run that case. We've got there's definitely local authorities are already refusing to fund on that basis. And of course, we're not mounting a challenge.
Yeah. And this is the thing, is this is part of the issue, isn't it? That like the how these issues are dealt with varies between local authority to local authority as
Absolutely.
well, doesn't it? Which makes it even more challenging.
Yeah.
And I mean, periodic payments, look, for the most part, in terms of my own practice, the cases that I deal with, the periodic payments are usually for care, for ongoing care, case management costs. If they do not relate to that head of loss, if they related to something else, so lost earnings or whatever, with that, well, we'll have to do a separate episode on it, Rachel, because we'll use up all the time. But basically, the message is, if you've got a case where there are periodic payments, that you're much more vulnerable.
Yes, absolutely. And that really needs to be considered a
Yeah.
lot at settlement stage, especially people who with contributory negligence issues. So
Yeah.
the reduction, if you're looking at a large reduction, that really needs to be really thought through.
Yeah. Yeah.
And I think it needs to be really thought through now, because the time is not right, because there will be a challenge, and that will have a huge impact on so many people if that's interpreted in the way I think it should be.
Yeah.
Well, it
Yeah.
should be, but legally.
Legally is
Yeah,
correct.
yeah.
Well, we'll circle back to that, Rachel,
Yeah.
another
Yeah,
time.
again, Emma.
Thank you so much, Rachel. That was so interesting, so helpful. And I think the main benefit of doing these sessions for me as well is that there's always kind of practice points flagged for me constantly to be adding to an enormous list of things for me to think about. And this is
Is that a
something
good
else.
thing or a bad thing?
It's a good thing. It's a good thing. Improving practice and thinking, flexibly about things. And in a more kind of diverse way is really helpful and super interesting. Thank you so much, Rachel. I'm going to make sure that when we post the recording that you're tagged or whatever, on the social medias, whatever, so people can find you if they need you. And yeah, if anyone has any follow-up questions, get in touch. Let me know, let Rachel know. And we hope you enjoyed it. And thank you so much for joining. Thank you again, Rachel.
Thanks for having me.
See you
Take care.
soon. Bye.
Bye, Emma. Bye.